Oklahoma death row inmate Richard Glossip says his case heard before the U.S. Supreme Court today, had his case heard before the U.S. Supreme Court today. He didn't ask them to take him off of death row, but grant him a new trial in light of what his supporters say is new evidence that shows problems with the star witness in this case. Our Devin Lyon breaks down the arguments from all sides.
This is the key witness, and the jury has just seen him under oath lie to their faces. And if that comes out, I mean, whatever other problems with his credibility that the prosecutors have at that point, they have a much bigger problem at that point. And without his testimony, there's no way to get the conviction of murder, let alone the death penalty.
That was just a portion of what attorneys told Supreme Court justices about the murder trial for death row inmate Richard Glossip. Glossip was sentenced to death for hiring a man named Justin Sneed to murder his former boss, Barry Van Treese, in 1997. Glossip claimed his innocence then and still does now. Oklahoma Attorney General Gentner Drummond believes Glossip is guilty, but still thinks he deserves a new trial because Sneed perjured himself at Glossip's trial.
This is a witness who lied, and this is a witness who, at the mid-trial inducement of the prosecutor, changed his testimony.
They also say the prosecution did not reveal important evidence around Sneed's mental state or the medication he was on when he took the stand.
About his history of psychiatric treatment, including the fact that a prison psychiatrist prescribed lithium to treat his previously undiagnosed bipolar disorder. The prosecution suppressed that evidence and then failed to correct Mr. Sneed's perjured denial.
Attorney Christopher Michelle was appointed to argue that the conviction was valid and a new trial is not needed.
For the past 20 years, the Oklahoma Court of Criminal Appeals has reviewed and upheld petitioner's conviction 6 separate times, finding compelling evidence that he commissioned the murder of Barry Van Treese.
Drummond was in Washington, D.C. for arguments. He sent this statement, quote, "Oklahomans deserve to have absolute faith that the death penalty is administered fairly and with certainty. Considering everything we know about this case, justice is not served by executing a man based on the testimony of a compromised witness."
You can kind of get a read on how the justices will rule with their questions. This case is not necessarily liberal versus conservative by any means, but when it came to showing sympathy to the Van Treese family, we saw from the conservative justices, Samuel Alito and Clarence Thomas, support for keeping Glossip's sentence in place.
And they're saying, look, it did not happen. And why wouldn't they be interviewed? Why don't we have materials from them other than in an amicus brief in this case?
Well, with respect, Justice Thomas, you do have materials from them. Ackley's affidavit is in the joint appendix before this court. And it's not like Smotherman never talked to anybody. She's talked to people at various junctures, and her story has changed over time. Again, I don't want to overstate the point because we didn't resist an evidentiary
But
hearing.
they are central to this. It would seem like any dealings with them would also be central, and we would not be arguing about NAPU and Brady if that had been cleared up.
Now, Alito and Thomas were concerned that the prosecutors in the Glossip case were possibly being smeared 20 years after the fact and after time had passed. Thomas said he was disturbed more prosecutor points of view about their actions, including official interviews on the Glossip case, had not been entered into evidence, but had only come up in briefs. One justice who appeared very sympathetic to Richard Glossip was center-left Justice Elena Kagan. She openly said Sneed lied on the stand and the defense was at a disadvantage in her opinion. Here is that exact exchange the court appointed counsel to defend Glossip's death sentence talked about it with her.
He lied on the stand, and in a case where the entire case rested on the testimony of one person and his credibility, if you can show that he lied on the stand when he said, "I never saw a psychiatrist and I didn't get a prescription from the psychiatrist. It was, they gave me lithium for a common cold." And then the prosecutor says, "Well, that was a lie. I better correct that under NAPU," and doesn't. That seems pretty material to me. I mean, it's just your one witness has been exposed as a liar.
A couple of responses, Justice Kagan. I think first there are threshold elements under NAPU, including whether this was false testimony. I don't think it was false testimony, but I want to take your question on its own terms. This false testimony that Sneed saw a psychiatrist, that would have been harmful to petitioner under his theory of the case. Remember, the prosecution...
False is false. Like whether you can parse the content of the testimony this way or that way, the critical question that a jury is asking is, do I believe this guy in everything he says?
The court-appointed attorney representing the Van Treese family and the death sentence says Glossip's attorneys knew Justin Sneed had a mental illness, but they never pointed it out because they thought it would hurt their case by showing Glossip manipulated Sneed to carry out the crime. But Kagan says openly the star witness is proven to be a liar. One justice who did not ask any questions today was Neil Gorsuch, and he is not taking part in this. Before he was appointed to the Supreme Court, Gorsuch was part of the federal appeals court that handles cases out of Oklahoma. At some point in all of this, Gorsuch was, and the court he was a part of previously had a hand in another Glossip appeal. In order to avoid bias or a conflict of interest, Gorsuch has stepped away from this, meaning 8 justices, not 9, will rule in this case. With Gorsuch sitting this one out, it is possible a 4-4 tie could happen. If that happens, like it has in the past, the lower court's decision stands, or it is believed in this case, Glossip's death sentence will stand. Even though arguments were made today, that final vote and decision will not happen until late May or early June of next year.